Welcome to the Binary Agora. I'm your host, Alba Rivera Martinez, and a couple of episodes back, I sat down with Tim Cohen to explore how he worked to change the reality in Google search relating to AI overviews, which has finally crystallized into the CMA's remedies imposed on this gatekeeper. So following on that conversation and those remedies, publishers are rethinking the whole structure of incentives embedded in search engines and how AI overviews intersects with the promises of delivering results for them and also to consumers. So to discuss this proposal and also some additional solutions relating to how web publishers may interact with search, I have with me today James Rosewell. He is the director of Movement for an Open Web, as well as CEO and co-founder of 51 Degrees. So welcome to the Agora, James.
Thank you for having me. I should just say my relationship with Tim Cohen is that we founded Movement for an Open Web together. So Tim brings legal superpowers and policy superpowers, and I bring engineering and entrepreneurial powers. So together we're greater than the sum of our parts.
Absolutely. And I would say that before getting into the nitty-gritty of the proposal that you wanted to present today, I wanted to ask you briefly, what do you think about the CMA's remedies that really enable publishers to try to opt out from their content being integrated into AI overview? So what do you think about those remedies? Is opt out the correct solution there?
Well, I think if you go back to July 2025, it was ourselves, Movement for an Open Web, and Foxglove, who originally asked the CMA to use their injunctive powers to limit Google's AI overviews. They haven't done that, but they've done something, and they've done it in under a year. So we could say, that's a progress of sorts. But what they've actually done doesn't really change things particularly. Yes, you've got to opt out. We don't know how that's going to look. Google typically will introduce lots of complexity and chicanery, and whilst the largest might be able to benefit from that because they have the time to be able to work out how all the dials and knobs and interactions work, smaller players may not even know it exists, etc. Where it is helpful is, I think it's section 9, is it does contain a language around retaliation. So a big fear any publisher has is where Google searches, or Google more generally as a large source of traffic to their website and therefore is proportional to revenue. They might be penalized for using alternative solutions to those that Google put together. And the CMA have at least given some consideration to that.
So thank you for that, because actually on the channel we already had some scholars discussing that opt-out is not really the way forward and maybe opt-in is an alternative to that. So I wanted to ask you with that you had the chance 2 weeks ago to present your proposal on how publishers should be remunerated, in your view, by Google to get AI overviews to pay for their content. So I wanted to ask you whether you can outline what you came up with at Movement for an Open Web and how it substantially improves this bargaining position of web publishers vis-a-vis Google.
Yeah, so firstly, Google are one company involved in AI. There are many others, large and small, well-known and less well-known. So I think just before we finish the conduct requirements, what we're really looking for in relation to Google specifically is the unbundling of AI overviews, their Gemini product, from search. So what happens is even if you opt out and you follow whatever process gets put in place under the conduct requirements, you're still then reliant on search, but search has been pushed down, and being number one in search doesn't mean the same thing as it did 3 years ago. So really what we want to see is the unbundling so that Gemini operates as a separate product to search.
Would that, for instance, would that work, for in the same way as, for instance, AI mode is now included within the Google search, or would you have it as a completely different standalone service?
It'd be completely separate. So that bundling wouldn't be allowed. And indeed, that is exactly what happens in France. So many people in the advertising and publishing industry would have just been in Cannes for a week, enjoying the sunshine and the Prosecco. And if you'd used Google products whilst in France on a French IP address, then you would not have seen this bundling. So it is perfectly possible, and it also shows that the French regulator has teeth to the point where Google do not do this tying in France. So it's entirely possible. That's what we would like to see around the world. But that doesn't really sort of directly address your question, which is moving on to AIs more generally. So the problem with the opt-out is it kind of has the premise that there's a right already in place for the AI company or indeed any commercial entity to use the content without having a license or permission or whatever. It's the equivalent of, okay, you've left your bicycle outside your property and you haven't locked it up, so I have a right to ride it and take it and use it. And that's just wrong. It's just absurd that, we're even having this conversation about ownership. It's very clear going back hundreds of years how ownership works in our societies.
So expanding on the analogy, it would be a kind of free riding.
Yes, precisely. Yes, it works very well there, doesn't it? What we did is say, okay, well, there's text and data mining and there's copyright and all these things, and they are being disputed and they're complex, and this isn't going to benefit the small publisher. So we looked and said, well, what do we need for the very smallest publisher? And let's work up. I think a lot of the thinking is often done at the largest and then doesn't flow down very well. So we looked at simple contract law, but what would happen if we made the contract very clear and therefore a license was generated. So what we created was the search-only contract. So this is a standard document. It covers the requirements of all the publishers we've spoken to who are happy for human viewers to make non-commercial use of their content. So to read a news story, read an article, watch a video, see an image, etc. And they're happy for the content to be used in search as defined by Google pre-2023, before Google introduced the AI inclusions effectively in their search contract. But any other use, they're not happy with. They don't want to license that. So what we did was use a contract document that sets up a charge, very much like a parking charge. So if an accessing entity, whoever that accessing entity is, accesses a website, a charge then becomes due. The default charge is £500, but that can be adjusted by the publisher, and that's per asset. So an asset might be an article, an image, etc. So you could have an article with 2 images, that would be 3 assets. At the default pricing, that would be £1,500. And that fee becomes waived if the waiver condition is met, which is non-commercial use or search. If the waiver condition is not met, then the debt can be collected. And it can be collected through the county court system. So this is the legal system that, a plumber or a tradesperson, say, was doing work in someone's property, and then the property owner didn't pay them. They would go to the county court in the UK to get that payment made if they couldn't reach an agreement with the other party. So it uses exactly the same court system, but it doesn't have to be that court system. It can be any other court system. It's just that's the one that is by default. There's provisions in there to prevent anti-publicity clauses coming in, to explicitly reject the accessing party's terms and conditions on the principle that if you own it, you decide how it gets licensed, not the other way around. It's the equivalent of, I like this bike, I'm just going to take it and ride it. And the person who owns it doesn't get to say, no, 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 no. There's a bit more to the contract. We can explore that in a little bit more detail. What it does is it describes the remedies as well. So not only does it talk about the legal system, it describes the remedies. So it's very clear. There's no ambiguity. And basically what would happen is a publisher who's deployed this contract would then look at the AIs, the output from the AIs, and they might ask a question. So let's say we wrote an article about a particular player in a World Cup team, and it was a very specific article, and you went into the AI and you put in a prompt about tell me about this player, and then content from that article that's covered by this license becomes available in the AI result. Now that could be a verbatim quote, or it could be a link in sources going back to the the original article. Then we have evidence. So we know that that particular AI response contains information that's covered by this license. So we know that a fee has become due. The waiver has not kicked in. So what you can do is you take a screenshot of that. Obviously, make sure as a publisher you've got a copy of the time when you put the license agreement into effect, and then you've got the original article. So with those 3 pieces of information, you write a letter to the AI company. We've listed the addresses for the major AI companies on the Movement for an Open website, and then you give them a reasonable length of time to pay, so 30 days perhaps. If they don't pay and you don't get a check or a bank transfer, then you can issue a letter before action. Again, we have templates for all of this on the site. And then finally, if the infringing event took place in the United Kingdom, or can be tied to the United Kingdom. So that doesn't mean to say that everything has to be within the United Kingdom. As long as the United Kingdom is part of it, then you can start a money claim online. So this is a simple web form. If it's £500, it's £50 to file the claim, and then the process starts within 6 to 9 months. If a settlement isn't reached, then it'll go in front of a judge, and the judge is only considering the license and the contract. They're not considering text and data mining and copyright and all these other kind of things. It's very, very narrow. We can't see how a judge would possibly rule against a publisher who's got the right evidence and implemented this. But of course, that's being tested by the early adopters at the moment. This process is underway, and the debt becomes due. So what we would find then is that a price has been established for content, obviously based on the publishers, and for those publishers that wish to deploy this, they've ended freely available, or free riding, as you said. And it doesn't really matter what the CMA do or other regulators do, because this is just based on contract law. So, as I said, Section 9 of the conduct requirements is helpful because this is another method of licensing content. So Google cannot reasonably retaliate against those parties that wish to use it. What would happen if this were widely deployed in a particular sector? So if we take sports writing, for example, then the AIs would be relying on very poor quality information that wasn't covered by this license agreement. So if they wanted to use content from, say, professional sports writers, they wouldn't be able to use it without paying for it. So this is very much a case on why, Tim and I, and we'd like everyone listening and watching to keep spreading the message, because this isn't an us thing, it's a we thing. If all publishers started doing this, then it would materially change the game. And that's why we've made it free and super simple to implement.
First, in terms of purpose, if I understood correctly, this would only apply to those cases where the publisher can actively prove that the AI, for instance, an AI chatbot, has used its content directly. And I'm thinking, for instance, about, so as you said, data mining would be excluded from that. Scraping without using the content, would that be included? On top of that, we have seen that, for instance, AI overviews now with a Munich regional court saying that AI overviews does not really extract content as such from websites. So in special circumstances, what it does, it collates different websites into the search box. So I was thinking whether those types of scenarios would be under the scope of the solution, or whether it would have to be dealt in another way.
What you just described is conditions that would not trigger the waiver. So importantly, the accessing entity can take a copy of the content. The license is about what they can use it for.
Okay.
So if you were to take search, for example, then Google could take it in one go, put it into search, but they couldn't use it for all the things that you just described. So what you're now talking about is the evidential sort of bar, effectively. So what I described was fairly straightforward and very often happens, which is where you get a prompt to clearly show that the information's been used. That will not currently be available from most AIs unless they start providing telemetry or detailed information about the internal workings of their solution. But the liability is still there. So if in 3 years' time, a particular AI is opened up and the activities you just described are found to be happening, then the evidence would be there and the monies would become due plus interest, since the evidence of the infringing use, which didn't trigger the waiver, so the debt would become due. So what this is also doing is building up liability for the AIs.
Okay.
Yeah. So they need to negotiate a license in order to address that liability.
Okay, and you were also talking in terms of scope, that it can only apply to the UK, or when it takes place in the UK, or whether that's broader in scope, because I'm thinking, so how would this, for instance, work with the now imposed CMA remedies? If in the end this does fructify into a clear solution for publishers, how can then that be expanded into other jurisdictions?
Of course. So just to be clear, the CMA conduct requirements and the CMA activity is pretty much separate to what we're describing. There's not a relationship between the two. The CMA conduct requirements is helpful, particularly for the retaliation language, but the two are kind of separate. And we're obviously talking to the CMA and other regulators about this. It would be rather nice if they said in an update, they said a search-only contract and similar license agreements are entirely legitimate alternatives that Google must respect. And that would be helpful. It would raise the profile of the solution and give those that perhaps would be more emboldened by a regulatory endorsement the confidence to move forward. Now, when it comes to the other jurisdictions, if you can tie it back to the UK, then you can use the UK courts. If everything cannot be tied back to the UK, then we would need to look at other jurisdictions, which broadly have the same principles, right? I mean, this is ownership, contract law, etc.
Yeah.
Yes, the history might be slightly different in different parts of continental Europe, for example, but the basic principle applies. So all of these documents are on GitHub, normally used for source code, but are very effective at handling community contributions. So if you're a lawyer or you have access to a lawyer in Spain, France, Germany, Italy, Denmark, Holland, etc., then feel free to look at amending the license. We can produce a version 3 that basically includes language for different jurisdictions. So our desire would be that we have another iteration of this document that makes it clear what happens in other jurisdictions, and we simply add them to the same document. That has the advantage of it being a global document rather than creating one for each individual country. Another important feature of the solution is that by having the same document on the same URL, it becomes machine readable by virtue of it being the same URL. So, Perplexity could look at that URL and they could read the document and they can say, okay, this is how we're going to implement it in our systems. Google could do the same, OpenAI, etc. They all do the same, but it's up to them to decide how to respond to the license. The problem with some of these solutions that seek to create a vocabulary or an enumeration of uses is they are ambiguous, and that benefits the AI in the battle of the forms. So if you have a solution that says, research, training, indexing, RAG, grounding, etc., then these terms are quite weakly defined and there's no enforcement, breach, etc. There's kind of a reason when you hire a car, there's quite a lot of text, or if you read the whole document when you stay in a hotel, there's quite a lot of text. I know not everyone reads them, but there's quite a lot there. It doesn't just say be nice. There is actually specific text and language around each party's liabilities and responsibilities to each other. So, those sorts of solutions are dangerous when it comes to machine learning. The advantage of this contract, though, is it gives the features of machine learning by having a standard URL, but the benefits of a binding license.
Okay. And so talking also about retaliation, so I was thinking many big web publishers already have agreements with these AI companies. So I'm thinking maybe that a gap or a divide starts to cement in terms of, okay, all of these publishers that have agreements with AI will not apply this, whereas the smaller web publishers will apply it, and maybe then they can face retaliation through other means, i.e. search. Building on the CMA's language on retaliation, how that can be extended to this scenario in particular.
Well, there's two parts to the answer. So the first is the licensing. So yes, we understand that proprietary specific agreements have been entered into by some publishers and some AI companies. And that's, of course, fine. Movement for Open Web is about an open market, open competition that allows the web to flourish. So that's perfectly legitimate. Groups like the Spur Coalition are looking to publish licenses effectively and talk about best practice that applies to the smallest as well as the largest. And I would expect that in the not too distant future that they will start to publish kind of template agreements that perhaps draw inspiration from the private agreements. And in fact, it's only with many template agreements can we address something you mentioned earlier in the conversation, which is the telemetry. So what's actually happening within the AI? That would be a legitimate next step. But you can't agree or decide upon telemetry until you know what the licenses are that are going to need that telemetry in order to enforce it. You either end up missing something or you have something that's too complex. So we need to avoid putting the cart in front of the horse, as they say. We need to do things in a certain sequence. Now, the second part to do with the larger organizations is, let's say they have capacity or so far have entered into negotiations with 3 AI companies and they have a license for those 3 AI companies. If everyone else is able to steal the content that those parties are licensing because they haven't taken steps to easily protect and then enforce, then are they really going to be getting the best deal from those companies that are paying them? If I were to charge you 20 euros for something, but allow everyone else to steal it from me, then why would you pay the 20 euros? You'd be like, well, it's nice I'm getting all the warm, fuzzy feeling, but the value to me is less because everyone else is stealing it. It's quite similar to the piracy kind of debate of, Pirate Bay and BitTorrent and Napster and all these kind of things back in the day, where protections need to be put in place. So, of course, these larger publishers are free to decide how to protect their content. I think we all know that the bot blocking doesn't work. If you look at an article in Press Gazette week before last with Candor Media, Chris Dicker talks about how bot blocking just doesn't work. So it's a bit of a fantasy. It's a fiction. This kind of Cloudflare will protect me. I can turn the bots off kind of thing. It just doesn't work. So they need to have something with teeth. I think this is a very attractive option to them. But of course, that's part of the excitement of this moment is debating, what businesses want to use, what protections are available. But I think it's entirely logical and straightforward for the very largest to use this as well.
And in terms of price, so since you were also talking about the situation that we can compare with regards to bigger publishers that already have agreements and they can maybe agree on better prices. So I was wondering I think it was £500 per asset price. Where does that come from? So is this a standard within the industry, or is it something that you came up bearing in mind, for instance, the efforts that go in generating content and generating images?
So firstly, the £500 is just what happens if you don't. When you incorporate it into your website terms and conditions, don't specify an additional price. So you could put £5,000, you could put €100, you can put whatever price.
But it's the baseline.
Yeah, it's the default. It's the default. And it was chosen for two reasons. One is it's broadly defensible for most publishers. So let's say, just for the sake of argument, you put €1,000,000 per asset. A judge is unlikely to go, that was reasonable.
Yeah.
Again, it might vary by jurisdiction. You can argue, well, the license is the license, but it's less defensible. And £500 is pretty defensible. It's like, you've got hosting costs, you pay people, you've got the opportunity loss associated with any advertising or subscription revenue. It's kind of reasonable for even the smallest publisher to defend at that price. And then the other reason is the fee for money claim online for a £500 claim is £50. So we think it's reasonable that most people would be able to say, okay, a £50 fee to cover all the court costs and everything that would be needed to go all the way eventually is reasonable. It's not off-putting. And really what we'd like to do in kind of one limb of this, depending on how the AIs respond, is have every publisher who deploys it pick one article and go to court. We'd then end up with a lot of claims. If that ended up tying up the county court system, then great. It would be a problem for the Justice Secretary to deal with, and it would gain publicity, much like when, the farmers legally drive their tractors into the middle of cities. It kind of, it makes a point, doesn't it?
Okay. And to finish off the presentation, so you were saying at the start of the conversation, you would like to see AI overviews bundled from the search engine. So I was thinking, let's assume best case scenario that this does work. Small publishers do adopt this licensing scheme and then go to court. They can be compensated if, for instance, the AI companies agree or if a judge decides it to. But let's, for instance, assume that AI companies are not too happy to agree to these terms. So what is the future of AI if content gets, in that sense, priced and there's not so much of an incentive to, for instance, perform scraping? So AIs will be less reliant in terms of the content that they deliver. So is this a problem of these AI companies that they should handle, or is this a collective problem that we must address collectively?
Well, I think for the AIs, it changes the equation. So they pay for power and chips.
Yeah.
They have to. Yeah. What this does is it means they have to pay for information, and that then becomes something that they can differentiate from. So a premium AI might pay for a wide and diverse sources of information, whereas another AI might choose to just use user-generated content that may be not associated with a reputable journalist or content creator or whatever it might be. So rather than everything being free, or most things being free, they have to value information. What it does for the AI revolution is it means that the entities that benefit from the AI revolution will be broader and more reflective of society, which makes it more sustainable. And I think that is a very, very good thing. If we
Mm.
don't do anything, then the people that will benefit will be the shareholders of predominantly US companies. And we've already seen that with Google, Facebook, Apple, etc. So I think this is essential. I think it's fair. I think it makes the AI revolution benefit potentially everyone. Wouldn't it be amazing if an illustrator or a photographer or a journalist got a check every month from the derivative works that were created? Yeah,
Mm.
this is great. It's not stealing, it's fairly recompensing me for my work and the derivative works. So I think this is the potential of making, something that could be very damaging to society, and a revolution that could be damaging to society, one that works for far more participants.
And so this is my very last question, I promise, acting a bit devil's advocate. So maybe within this equation where AI companies have to assume this cost, then they will pass on these costs onto consumers. So maybe this is also a disruption on the other side of the market, where consumers can be in the end harmed through this type of content. So what would the response be to that?
Well, it would be like saying that you can kind of just strip mine raw materials and destroy the planet because consumer price is the only factor that matters. I'm not sure, that's the way we think anymore. I think we've kind of moved on from that way of thinking. But yes, of course, it does mean that consumers have to pay a fair value. And I think that's a conversation that is long, long overdue. How do the products that are now
Hmm.
fundamental to
Yeah.
society, like search and messaging and all these kind of things, how do they get funded? They get funded from large US tech companies and advertising. If we take the CMA's 2020 report into digital markets, I'd strongly suggest
Hmm.
anyone listening to this just looks at the executive summary there. So this was in July 2020, and it concluded that in 2019, the cost to each individual UK household in the additional cost of goods and services due to the digital advertising controlled by Google and Facebook was £500. Today, if you take the AIB UK's numbers, that's over £1,200. So let's be clear, people are already paying, and that money is not going, particularly in the case of AI, if it becomes the dominant form of advertising distribution in digital over the next few years, that money is not currently flowing to the people that sustain it and create it. So I'd urge anyone who's sort of looking at it from that angle, just consider the wider environment that we're working in and the wider ecosystem.
So thank you so much, James, for that. As ever, I will include all of the developments, reports that you touched upon in the comments below. If you have enjoyed this conversation, subscribe, like, rate the video, and thank you so much, James, for participating here in the Agora. And I expect to have the opportunity to maybe meet soon. So thank you so much for joining the Agora.
Thank you very much for having me, and thank you for listening and watching, and please do deploy that contract.